Okay. We pray for our situations to change, while we forget that situations were designed for us to change. With those words, I, Parishkar Shresht, on behalf of the School of Legal Studies, welcome you all to our workshop on patent and COVID-19 issues and challenges. Here, I would also like to welcome our guest speaker of the day, Ms. Isha Sharma ma'am, founder, TRAYAMBAK Overseas Private Limited, Noida. Our in charge, School of Legal Studies, Dr. Gitu Singh ma'am, Ms. Trishla Singh, Department in charge, and a special welcome to all our live viewers on YouTube. For this event, I would like to sincerely thank the management of Babu Banarsi Das University, our chairperson, ma'am, Mrs. Alka Das, our vice chancellor, sir, Dr. A.K. Mittal, our in charge School of Legal Studies, Professor Dr. Gitu Singh. We are fortunate enough to have with us our distinguished guest and expert speaker, Ms. Isha Sharma, ma'am, founder, TRAYAMBAK Overseas Private Limited, Noida. An M.Tech from Amity University and a law graduate from CCS, Ma'am has conducted intellectual property awareness workshops at IIT Patna and at Geeta Law College Panipat and has also conducted a patent agent training at United Lex Law Firm for employees at Gurgaon. She has also delivered lectures on intellectual property at IIPTA Delhi and ITIE Mumbai. She has been the speaker at Business Entrepreneur Summit Delhi, Cardio Merchant Conference Singapore, Dr. B.R. Ambedkar Center for Biomedical Research, University of Delhi, an introduction to IPR and career opportunities, Zoom for law audience. Ma'am has been a panelist at IPR Summit at Amity University, Noida. She has also been mentor on trademark process and case studies at CIPM Jaipur and has also done Insta live sessions on IPR for artists. She has to her credit the certifications for Certified Patent Agent, SAS certification, Six Sigma certification, digital marketing certifications. Moving on to our workshop, COVID-19 has completely upended the way we work, but the most disruptive and tumultuous times can also be the ideal moments for innovation. And if you are ingenious enough to devise anything or have come up with a great innovative business idea, then the next step would be to get it registered or patented. But to get this done is not so easy, and the prevailing COVID conditions has also added to the burden. So, what are these issues and challenges? We can listen from the expert itself. So, without further ado, I now request Ms. Isha Sharma ma'am to kindly enlighten us on this topic. Also, I would like to intimate our viewers that if they have some topic related queries from our expert speaker, they can post the same in the chat box on YouTube. Over to you, ma'am.
Thank you so much, sir. Thank you so much for your wonderful introduction. I'll be sharing the screen. Just give me a Just let me know if it's visible.
Yes, ma'am, it's visible.
Okay.
The first screen is visible.
Right. So, again, thank you so much for the wonderful introduction. So, I will just like to skip this part. Let me just start with the basic introduction of intellectual property. We'll be catering to what were the challenges in terms of COVID scenario, specifically into IP domain. But then prior to that, I would just like to brief you a bit about intellectual property. What are the different kinds of IPs, and then how can you file for those IPs, and what were the challenges faced during the filing in terms of the environment and in terms of the innovation itself. So when we talk about property, there are different kinds of property, and I'm sure that all of you must be knowing about these different categories. So one would be a movable property, everybody is having a car or a pen or a furniture and a dress. All these things can be moved from one place to another. So it is termed as movable property. Second thing is your immovable property. So anything which is fixed into a particular area or a premises can be considered as an immovable property. So your land or your buildings can be considered as a immovable property. Now, intellectual property basically is a kind of property that is created by application of the human mind. That is why the term intellectual comes into picture. And that's how the property which you have generated by applying your mind comes into picture. So most of the time whenever the term intellectual property comes into the discussion, most of the people feel that it might be related to the residential kind of laws or anything related to a different category altogether. But what IB means is anything which is arising by your human intellect will be created as a intellectual property, and then subsequently you can protect it by different means. So these are different kinds of IPs, and primarily in this session, we will be more focused towards patent applications. But just to give you a brief, it is always good to know what are different forms of IPs, because whenever an innovation comes into picture, only one specific form of IP will not be applicable. It is going to be different applications for different forms of IP to protect it in a, you can say, an infringement protection circle in relation to your innovation. So first thing is pattern application. We'll be studying it eventually. Second is your design applications. So anything which is like aesthetically appealing to you, which can be your say mobile phones or your car designs or your watches designs. If it is the outer appearance of the product as such, and you want to probably buy that product just because it is appealing to your eyes or you think that it is looking good, that contributes to the industrial design part of the IP. Then it comes to trademark application. So trademark, say taking the same example, if you have a mobile phone and different people use different brands. So it can be an iPhone, it can be a Samsung phone or a OnePlus phone, whatever is your choice. Now all of them have a brand name as well as all of them have brand logos by which you distinguish that, okay, fine, this is a Apple iPhone and this is a Samsung mobile phone. So these are the brands which actually categorize the different line of businesses and one enterprise product or services from the other enterprises. It can be a product mark and it can be a process mark, process or service mark rather. So when we talk about a product mark, we have already discussed a mobile phone or a watch or your shoes or your dresses. When it comes to services, we can take an example of your telecommunication providers or your airline providers. So your Airtel is different from Vodafone and is different from Jio. Which kind of SIM would you like to prefer or a network you would like to prefer depends on the credibility of that brand. So probably you will go ahead with that category. Other than that, when we talk about service industries, we can also take examples of airlines. So somebody wants to travel only by Indigo, or somebody wants to travel by Air India because of the kind of service that they provide. So these are the kind of different categories into trademark applications which can be filed. Then we have geographical indications, which are primarily location specific. So if a particular jurisdiction provides certain kind of characteristics to that kind of product, we file for geographical indications. So your Tirupati Laddu or your Kolhapuri chappals are these examples of geographical indications, and these are community rights. These are not individual rights. Then we have layout designs, topographic integrated circuits, which basically means if you have created any kind of integrated circuit designs, then you have to file for a different form of IP. Then what cannot be protected in these subheads of IP will be falling under a trade secret category. So anything which need not to be filed as such, which can be kept as a secret and will not be guided by any laws and regulations, But then to safeguard trade secrets, what you can do is you can draft a leak proof legal documents, or probably your security systems should be high. So when we talk about IT industries, in IT industries, what they do is to maintain the trade secrets, they don't let the people take photographs, or probably take any devices like pen drives or mobile phones where the data can be transferred by any means. So keeping a trade secret is a, I would say, an internal task rather than a legal support system. So whatever cannot be filed as an IP can be kept as a trade secret. Then we have protection of plant varieties. So if you have created any kind of a different plant variety, there is a plant variety act that can safeguard those forms of IP. Then we have copyright applications. Copyright is primarily for some kind of artistic work, or you have any sound recordings, or if you have created any kind of movies or pictures. All these can be filed as a copyright application. Now, currently, a lot of people who are into education industry or any kind of you can say training industries file a lot of copyright application, because there the lot of new novel content is created. Even if you're writing a novel or a book, you would like to file for a copyright application. If you're into IT industry and you are creating a code, and you have created a different kind of an app which need not to be I mean, you would not like it to be copied by somebody. So what you can do is you can file for a copyright application for that particular category. Now this is a question basically would say is that all I asked was, can I patent my copyrighted trademark application? So this primarily is the problem which is existing currently when it comes to IP, because people will come up to you and say that you want to file a patent application for their company name, or probably a copyright application for the kind of design that they have created. Because see, as I said, that there is a clear segregation of different forms of IP. So you have to understand that which category will be falling under which form of IP. So if for the logo, for the brand name or logo, you're filing a patent application, it will eventually be rejected. So you have to take a very proper call, either by, if you're doing it by yourself, probably just read about it, that which form of IP is applicable under which category. If you're doing it through somebody who's qualified enough to help you out, then it's a best scenario. Then we have these example which will help you to understand that what are different forms of IP, and how can we segregate different categories for one particular product to draw a protection circle around it. So if you take a mobile phone example, there must be some kind of technology behind it. There must be some kind of data processing methods or operation systems, or any kind of novel chip systems. So all these things which are falling under technology related product or process can be filed as a patent application for one particular mobile. For the aesthetical appeal of the product, say if you see a iPhone which is having only one button, that is the aesthetic appeal of an iPhone. If you have a blackberry design, then it was a different design altogether. So if your design is novel, if it is appealing to you, the overall form, the figure, the arrangement of buttons, positions and shape and size and everything, then you can file for a design application for the same product as well. Now you must be coming up with some kind of brand name for your this mobile product. So if you're naming it as Nokia, or you have created a product design as well. So there are different categories of branding. One is a company branding name, and then there is subcategories of product branding as well. So you must have seen that a particular brand, a umbrella brand, comes up with sub brands to cater into different categories of line of business. Say Reliance is a umbrella brand. Now they have come up with Reliance Trends when it comes to probably the clothing chain. If they have come up with Reliance Fresh for all kind of your food related stuff. So these are subcategories. So if you want to give a brand name to the product also, you can do that. So for that, you can file for a trademark application. If you have any, say, logo or symbol into it, or probably a slogan as well, you can file for a trademark application. Now, for the same mobile phone, if you have any software into it, if you have any user manuals or any ringtones and images, so for that, you can file for a copyright application. And whatever is left out and cannot be filed in any form of IP can be kept as a trade secret. We've already discussed it that you have to write like very solid agreements to actually keep a trade secret. And the best example of a trade secret is Coca-Cola formulation. So nobody actually knows what is the Coca-Cola formulation because they have managed to keep it as a trade secret. Then we have now these are the I would say different ways to understand that which form of IP will be applicable for which category. Again, I'm repeating that if you have an idea of anything, if you want to create something, just having an idea will not give you any form of IP because idea cannot, unless it is implemented in some form of IP, will not give you any IP protection. So saying that I want to make a flying car will not give you any form of IP. But the moment you have this idea and you start executing it, if you create a flying car, that is basically execution of your idea, and now you can file for different forms of IP. So the idea remains static. Apart from that, whatever is expression of the idea or implementation of the idea, in terms of subject matter, you can file for a copyright application. When it is an innovation or a technical based product or a process, you can file for a patent application. When it is related to quality and identity, or you can say authenticity of the product in terms of product or service for a particular brand, you can file for a trademark application. If the idea is just executed in the appearance part of it, again, we are going to file a design application. Now, what is the need of IP? Why do we have to actually file for intellectual property rights? So there is, if you want to use it for your own purpose, then there is no need to file for an IP. But the idea of filing an intellectual property registration is to exclude others. It's not to basically include you because you, anyways, created it. So it is given that you're going to make it. Unless you created it after some time, which is already having the IP protection registered. So in that case, you can't do much. So the IP right is given to you to exclude others so that they don't infringe you. So it's basically a legal monopoly right that ultimately you are the only one authorized by the government to actually create this form of IP and use this form of IP. Then it comes to company valuation. So currently, there was an article which said that about 75 to 80% of the company valuation comes from their intangible assets. Intangible assets contributes to something which is technology related or your IP related. So if there is a startup or even for a big large corporate, it is said that apart from the tangible assets, which is like the residential properties or probably the kind of tangible assets that they have, anything which is related to the technological part of it will contribute more towards their valuation. So that is the reason that most of the startups and most of the mid-scale companies and even large corporates are focusing on research and development to create the valuation to a level where they can execute it in different manners. So for a startup, most of the time, why would they like to get an IP valuation is because probably they want to attract investors or they want to sell it off at some point of time. So increasing valuation by filing large number of patent applications or trademarks or copyright will give them more credibility towards it, whatever they're creating, because nobody would like to get into something which is not already protected by them and later on can't be filed by anybody else. Then you have goodwill. So as we were discussing about trademark applications or your patent applications, is that there is a brand identity which is developed over the years, and this particular company have their own clientele because they trust on them. They have a goodwill in terms of that particular line of business or the line of product and service. So example would be that most of the people would like to buy for a iPhone because they believe that Apple is going to give them a good kind of a product, and they have some kind of trust which is based on that company. So nobody would like to dilute that level of trust. So if Apple doesn't go into litigations and let the other people copy their different versions of patent applications or trademark applications, ultimately it will dilute their client. So nobody wants to do that. So that's why the protection of IP comes into picture. Then avoids free riding. If you don't register it, people will just subsequently use it, and you can't do much about it. So your entire resources, your money and effort goes into waste. So filing for an IP again becomes an important task. Then we have impacts on promotion for small and medium scale enterprises. So currently what is happening is that apart from protecting IP for actual protection, most of the people also file it to use it as a marketing tool to advertise that we have created something, that we are actually moving towards research and development. When we talk about an organization or we talk about uh, probably a university or an organization highlighting that we have these number of applications pending, patent pending, and different forms of IP applications pending or granted as well, it gives a different kind of credibility that okay, fine, there is a lot of research going on, there is a lot of effort going on in that university or in that organization. So it automatically increases your visibility into the market and can be used as a marketing tool as well. Then we have already talked about investors. So if you're a startup and you want to attract investor, filing an IP becomes a mandate thing. Then it facilitates licensing. So licensing and transfer is always an option for IP monetization, basically. So filing for an IP is one thing, but then after that, once you get an IP or you have already filed for an IP, apart from not letting the other person use it, how are you going to monetize it? So the monetization will be done when you start giving the licenses or probably sell off the technology. So once you have filed an IP, you are the owner. Now you can actually give different sort of licenses to different organizations, different corporates for using that. And we'll be eventually studying it in different slides that how in the COVID scenario, your patent licensing and patent transfers became a very crucial point of discussion, and it actually helped in a lot of scenarios in terms of COVID. So playing a crucial role in mergers and acquisition, of course. So nobody would like to merge with you if they feel that the entire technology is belonging to somebody else. So filing for an IP automatically will help you if you want to grow in the later stage. So just a rough about what is patent definition. Patent applications are monopoly rights which are given by the government to the creator. So whosoever created the innovation will have a monopoly right, which is given by the government to that concerned person or organization or company, depending on whosoever created it first, for a very defined period of time. And that defined period is 20 years. So it cannot be extended beyond 20 years, no matter what. Now, this is a short, I would say, filing process, but then there are a lot of other, I would say, sub processes which are involved. So, first thing that you have to do is conduct a patentability search to cross check whether it is novel or not, and then proceed with the drafting. Again, whatever you have created cannot be submitted as a prototype into the patent office. So, whatever you're creating right now needs to be written in a techno-legal format and filed as an application, and that will decide that what is your creation, not your actual product, because actual product might be different from what you have written, and eventually whatever is given to you at a later stage after going through the prosecution and examination and everything will be considered as your innovation. Then filing of the patent application takes place. So filing can be done in four offices. where either you can go physically and file an application, or what you can do is log into IP India website. There, entire information related to forms and fee structures, who can file, what will be the fee structure according to a startup, what will be the fee structure according to an individual category is given. Filing an application by going on IP India website. If you want to file an application, you need to have at least a type 2 digital signature to sign off, and then the applications will be filed. Even the inventors, whosoever created it, can directly file an application. You need not to actually go to a patent agent or a lawyer to file an application. But then you can log in if you have a type 2 digital signature. As an inventor, as an applicant, you can directly file the application as well. Then it goes under examination procedures. So there are concerned qualified people according to domains who are going to evaluate the application on certain grounds. And after that, if they feel that your patent application should be granted, they will give you a certificate which will be valid till 20 years from your propriety date. Or there might be certain objections which we have to cater. So filing to those objection reports, compliances, and all of that, hearing and everything. After that, your application will be granted or probably refused. Again, one more cartoon which says that one person is saying that I have created this, the other person is saying I have created this, and the third one is also feeling that I came up with this idea. So, patent application basically talks that whosoever files the application first, the invention will belong to that person. So, it's always first to file system, no matter who creates it, unless it is done by some kind of fraud or by some kind of other means. For that, you have certain provisions in the Patent Act to go after that person. But otherwise, it's not like for who invented it first. It's always first to file first, because the due diligence for who invented first was difficult. So the entire world shifted to the first to file system. Whosoever files the application first, invention belongs to that person. Now the definition of invention. Now invention basically has to be qualified on different criterias. These are major three criterias under which you have to filter out whether the application can be filed as a patent or not. First is your novelty, which basically means that anything which is naya or probably novel with respect to the filing, which basically means if I decide to file my first application on 1st April 2021, before that date, anything which is existing in the public domain will be considered as prior art. So if you have given up your entire inventions information, and probably by yourself or some you started disclosing it to other people disclosed it to somebody else, or by a research paper, or whatever means, if it is there in the public domain, you cannot consider it as novel. The first thing that you have to do is file an application and then publish it in any of the journal that after the patent pending status. Because if you do it otherwise, your entire innovation is lost. Then you can't do much about it. Then there is an inventive step. So inventive step basically means that anything which is not obvious in nature. Obviousness again is very subjective. So what might seem obvious to me might not seem obvious to you. And this basically means that the examiner or the person placing an objection is trying to say that what you did is you probably read few references, one, two, three, and after combining one, two, three, you came upon this invention. So it's not something which is created by you. It is basically derived from these references, and that's how you created it. So again, there are a lot of means to counter that. So inventive step can be countered. Third is your industrial applications. So it it needs to have a commercial application. It cannot be like an abstract idea which cannot be made. So say before probably 30 years I said that I have an idea of flying cars, and nobody was making a flying car. So unless I make a flying car and show that it can be made and it can be like uh, capable of being used, uh, this was an abstract idea. So something which cannot be done irrespective of whether it is novel or it is inventive, which cannot be made is something for which you cannot file for an application, even for a product in process. Then we have certain sections like section 3 and 4 in the patent act, which says about non-patentable subject matter. So after cross checking these three parameters, you also need to check whether it is falling under section 3 or 4 or not. If it is falling under section 3 and 4, you cannot file for an application. So for example, your software related innovations, if it is only per se software, then you cannot file for a patent application. You have to integrate it with the hardware. If it is like a copyright subject matter, artistic work or something, you cannot file for a patent application. If it is there in the public domain for so many years, you cannot file for a patent application. If it is related to, say, anything related to atomic energy or defense purposes, so if it's a product, then it's a different thing. So government will decide whether it is falling under that section category or not, and you cannot file an application. Now, moving ahead to the core topic of it. So, just I wanted to give you a basic idea about the patent first, and then moving to the patent protection in the times of COVID-19. Was that till I would say before lockdown happened, people were so the functioning of IP and even in terms of research and development was pretty much okay because people were focused in their particular domain and even before lockdown, I would say like 2 3 years before, the entire IP offices moved to virtual platforms. There were already video conferencing hearings which was happening. uh, I would say that that's majorly because of the international interference that we have. So there are a lot of treaties we are part of, and to be a part of that treaty, we have to comply with those rules and regulations that they have. They have different suggestions altogether because initially India was considered as one of the toughest and the longest jurisdiction to get a patent application. So your international influence was such that they wanted certain measures to be taken by the Indian government. So the virtual part of it for either video conferencing hearings or filings, online filings, was adapted way before COVID. Even then, the High Court or your other courts were not actually accepting those online filings. Indian Patent Office did it way back. So COVID-19 effect was primarily, I would say, towards the types of application that were filed, more towards that than towards the procedural part of it, because the procedure was anyways in place when it comes to online filing. So if you go to IP Indian website, it is very convenient to file an application. You can just check the information, what all forms are required for your kind of category, fill in those details, and file the application online. You will get an application number, and post that everything will be communicated through emails. So you will receive examination reports and hearing dates on your email itself. You just need to click on those links and appear for video conferencing, whosoever, either the applicant or the agent who is appearing for their behalf. So it was, I would say, pretty much in place even before COVID. But then COVID actually rushed the innovations more towards pharma sector, more towards product sector, more towards, you can say, specifically related to problems which people were facing in terms of COVID-19. So there were a lot of apps which were created, a lot of diagnostic kits, those were created, a lot of equipments which were created in terms of COVID as well. So people for whose core business was something else, and what they did was that nobody knew actually that for how long are we going to face this kind of scenario. So people started making products which were like short term requirement products. So People started making ventilators who were not into ventilator industry. People started making sanitizers who were not into sanitizers industry. But then they had those rough ideas because probably the line of business was connected. So most of the applications that were filed in the initial stage of lockdowns was just related to COVID-19 innovations. So I would say that the number of applications were increasing, but then the domain was very restricted because people stopped innovating or researching in their core technologies. So if I talk about cement industry, if I talk about say drone industry, just to give you an example, so initially there were a lot of applications which are filed related to drone, probably for defense or any other purposes. But then in the COVID time, they started integrating uh, the you can say the COVID part into it. So there were a lot of like temperature sensor drones for flying. Those could actually detect your temperature from a distance. Then there were like spraying sanitizers through drones and all of that. So the application or I would say the basic approach was related to COVID, but then the number of applications were fine. So these were like some of the core applications which was anyways done by the pharma industry. So they keep on working on drugs related to different diseases. So there are a lot of drug patent applications which are filed, API applications which are filed. So again, in the COVID scenario, everybody was working towards that. So they were creating kits, they were creating those diagnostic kits, and then they were creating sanitizer machines, and they were creating senseless, say, without touch, some sensor based kind of machines where they could, I mean, people need not to actually touch anything. So, removing the human intervention and solving the real time problems of COVID became the center focus of filing patent applications rather than their own core domains. And most of the pharma industries jumped into it because that was something which was looking lucrative for a very long time. So, that was happening during the COVID times. Right. Uh, Again, so one more point was that due to shutdown of most of the universities and most of the offices, the premises became a problem. So there were not too many laboratories which were open, not too many testings that could be done. So everything that could be managed from home, more or less app-based kind of technologies where people can create stuff which is having limited I would say requirement based on the human intervention was the kind of applications which were being filed for a defined period of time. And after that, when the unlock started happening, people started going to their offices and everything became back to normal. Because but then one thing which actually happened during COVID was that people became aware that they cannot run from innovation. So research and development should be a part of their business, irrespective of what is the outcome. So people started actually realizing the importance that IP needs to be given focus, because unless they start innovating something in their own core area as well, it will be difficult for them to survive even during the COVID and post COVID times as well. Because then there was I mean, a difficult kind of competition which was surviving in every industry. So people had to come up with a lot of innovative ideas to solve those things. So a lot of IP applications were filed in that domain as well. And in pharma industry and medical industry, everybody was just focusing on COVID-19. So developing a vaccine was the prime focus for about a year or so. So during that time, lot of state-of-the-art searches and FTO searches were conducted, because people wanted to know that if this vaccine or if this drug or if this technique is working for this particular virus, it might work for COVID as well. So people were actually discussing, a lot of discussions happening, a lot of patent application literature reviews were happening. Along with that, there was a lot of focus on creating the vaccines as well. So the entire you can say the research system was just focused on, let's solve the COVID-19 first and then move to other subsequent things. Then there were a lot of cross licensing happening. There was a lot of companies which announced that even if we hold for an IP, even if we get a intellectual property registration filed, or if we already have a intellectual property which is patent application on any of the drug which might be useful in this COVID situation, they will not be going into litigation to the company. So they were, it was, I would say, pretty much relaxed attitude in terms of giving licenses. So people, even the giants wanted to give license to the smaller companies without those infringement issues. So they said that probably we'll just give it without taking the royalty, or giving it a very low percentage of royalty. So the cross licensing and the licensing picture became very clear and very I would say it was a very best kind of a scenario where all the companies were working together to actually solve a bigger problem which was existing in the world. So it was not like let's fight each other over lawsuits related to the intellectual property that we hold, the patent application that we hold. It was majorly like let's work together wherever the one form of IP can be used by the other, or the other form of IP can be used. Let's cross license it. Let's create more of opportunities based on patent licensing and create a solution towards that thing. But then the financial difficulties were existing in terms of smaller startups. So whosoever was into initial stage of startup or a mid-scale company, filing for an intellectual property anyways involved certain costs, so they were facing a lot of difficulties with that part. But then government thought that it's always better to give a subsidized rates for people whosoever is filing under startup category or under individual category. So when I talk about IP, that thing was already existing even before COVID. It was existing, but post COVID also they felt that they need to restructure the fee structure to be able to help the companies file more forms of IP. So that was there. Now, right. So patent initially the most of the corporates and companies were relying on filing less number of applications, but then COVID helped them to understand that it's always better to actually help for multiple forms of IP in multiple jurisdictions, so that the kind of incentives or the kind of I would say achievability would be more in terms of global markets, because people started realizing that the pharma industry can actually have a larger impact on the entire world. So filing international applications will give them more credibility to the kind of innovations that they're having, or other than that, the royalty rates as well. So in terms of commercial viability and applicability, it became really good. Again, the patent pooling and medical patent pooling was happening. So patent pool basically it means an agreement between two or more patent holders to license one or several of their patents to one and another of the third party. So what they're doing is, rather than giving one licensing, which doesn't help actually, because the product, if you're developing a kit or if you're developing a product, might need multiple forms of patent application licensing. So patent pool licensing was also helping a lot of companies and generic market as well to solve that pandemic issue as such. In So in terms of world approach, MPP basically is like medical medicine patent pool, which is like uh, pretty much existing across the world. But then India is very strict in terms of licensing rules. So we also have, you can say, compulsory licensing provision where government can actually interfere if in case you are not able to provide the concerned drug or the concerned innovation which is needed by the public at large, and you're not providing it, say, either by giving it on affordable prices, or you're not able to reach out to the market. Government is going to provide a compulsory licensing, imposing the the company who holds an IP to give in compulsory licensing to the other company if they haven't agreed to give the license initially as well. So those types of things were discussed at length, and most of the people who were part of the pledge, which was taken in the month of November 2020, was related to MPP to promote the generic pharmaceutical products guidelines. So it was like, let's collaborate with each other and help each other, mid-scale companies and small-scale companies, to actually provide a larger number of you could say licensing opportunities to be able to cater to bigger markets. So that's how the MPP guidelines came into picture, and it was very helpful in terms of generic market. So one is a patent application, which is having a right till 20 years time period. Post 20 years, it goes to the public domain. So before those 20 years also, there the other companies whosoever are like competitors can actually start researching on it, so they can do those experimental trials and everything, and once the patent application goes off patent, they can start launching those products into the market. So these guidelines were very helpful in that terms also. Again, the compulsory licensing thing is very stringent in India. We don't have too much of compulsory licensing cases as of now, but even the legalities and you can say the procedural part is very difficult in terms of compulsory licensing. So people thought that rather than forcing the government to actually impose a compulsory licensing, it's always better to use a pool system kind of a thing where MNCs can actually collaborate with each other and get with the work done at the affordable prices. Because compulsory licensing will be less effective for the companies, but then if they give into pool licenses and joint licenses, then it becomes more credible in nature, and they don't have to actually give away at those compulsory licensing conditions as well. So it's always better. Now, according to the patent offices, when the COVID era hit, so they were actually struggling because a lot of filings were happening, but there was less of human involvement. So everybody was sitting at home. So managing the deadlines, and in patent applications and trademark applications, your deadlines are very important. So if you miss on one of the deadline, then extension of deadline might be possible, might not be possible. So all the offices, your patent Indian office, trademark office, your USPTOs, European offices, everybody announced the extension of timelines for all patent application filings and trademark application filings, be it your complete applications or be it reply to those examination reports. All of them kept sending notices, different form of notices, showing that okay, fine, we are extending the timelines to cater to your clients or to the people, so that it don't miss out on the technology, because it was a rare scenario. Nobody knew how to handle such kind of things. And to remove the exposure, even in India, they were actually not. I would say promoting physical filings. So they said that all the hearings will be done through video conferencing, because they were equipped with that, and they were not entertaining any kind of physical hearings as well. All the physical hearings which were opted before were also converted into virtual hearings. So that became a part of the system. Then the cash system was opted off, that let's stick to virtual online filing mediums only, where the applications can be filed through the website, so that that becomes a good thing. So actually, COVID-19 helped, if I specifically talk about India and the countries where they were not adapting to those measures, apart from US and Europe, because those are like prime jurisdictions where everything is pretty much well in place. So Indian market, in terms of, if you talk about non-IP, if you, or probably in terms of litigation as well, they started adopting a lot of virtual platforms. So High Court moved to video conferencing, and most of the people were actually opting for that only. But the filing and video conferencing could be done. But other than that, there were a lot of other procedural hassles which were happening. So that could not be catered. Right. Again, the relaxation of deadlines were mentioned, and it was automatically extended. E-filing facilities were already there, and they tried to promote it and became more functional. So these were the impacts. Probably I can take questions and help you understand that. If you have any further queries, we can discuss it and work about it.
Thank you, ma'am, for the wonderful session. Ma'am, due to paucity of time, we are taking some of the questions which have been asked from our YouTube live viewers.
Sure.
Ma'am, first question is from Alankrita Tripathi, and she asks, "What are the documents needed to file for an IP registration?"
Okay. IP registration again is a very broad term. So as we were discussing, that IP can be a patent application or a trademark. But let me just, because we were discussing patent applications, let me just brief you about patents as well. You need to go to IP India website. On IP India website, there are a list of forms which needs to be filled. Now, if you say, for example, if you're filing an application for the first time, you need to fill the form one, you need to fill form two, you need to fill form three, then you need to fill form five, which are for different categories. Like five is for declaration of inventorship, so which basically means that you are the one who created it first. So you have to declare it that I have created it first. If you are going through a patent agent, then a power of attorney also needs to be filed. If you're filing a complete application, along with, like, standard time period for publication is 18 months. So that is the procedure part of it. If you want to go for an earlier publication, you have to file for a different form. Then you are going for an examination, then there is a different form. So if you go to IP India website, they have clearly mentioned the types of forms which needed to be filed under which category, along with the fee structure. So if you're filing it under the individual name, or if you're filing it under company name, there is a fee structure involved into it. You can just look into it and file the application.
Okay. Ma'am, the second question is from Gunjan Shrivastava. She asked that, ma'am, during this the phase of pandemic, COVID pandemic, and because of the pandemic and the lockdown and the dire need of meeting the basics, people got a chance to enhance their creativity also, and
Right.
they came up with like making of the mask and the PPT kits and all those things, which can be also aided in the invention of vaccine. So,
Mhm.
ma'am, she asked that whether this type of invention and creativity can also get IPR protection.
Right, you can. So, when you're talking about those suits, or if you're talking about masks, so let's take an example of a mask. So, initially, there were a lot of applications which were patent applications filed in the mask category, because what they did was they were incorporating certain kind of sensors, certain kind of filters. So, if they're like 10 filter mask, you need to protect that filter technology itself. So there are patent applications filed. If it is just the aesthetic appealing mask, so if it's like a glass mask with some kind of like round shape, or probably covering your eyes as well, or whatever. So if it is a novel mask, if the idea is that if it is naya and it is not there in the public domain, you can file for some form of IP. So for the mask itself, if it is technology based, you can file for a patent application. If it is just the aesthetic appeal, that what is the design of the mask, then you can file for a design application. So subsequently, all these things can be filed under IP category. You can do that. But if it's a normal mask, like a cloth mask, which was there in the public domain from so many years, then there is no novelty. So you have to prove that there is some kind of novelty, and then you can file for an. So even for PP kits, for masks, there were a lot of design and patent applications.
So, ma'am, that novelty should have to be proved in terms of the material used or the way it has been made or something else.
No, so novelty basically will be done after cross-checking and conducting a patentability search. So material can also be new, but then if you're just saying that cloth is used for making a mask, it will be very obvious in nature that it's not something like in general also, even without the mask, you might just cover nose and mouth with some kind of handkerchief and something. So that will become under the obvious criteria, even if it is new, it was not made before, but still, if it is falling under obviousness criteria, it cannot be filed as an application. But if it is a mask having some kind of features into it, if some kind of design into it, then you can consider for filing a design application for sure. Same goes for PP kits. So there were a lot of PP kits which had some of them were using a material and the design in such a way that it created like 99% of the protection, or reaching out to a point where there was no penetration possible, or having some kind of additional benefits to it. If those things can be combined and we can do a prior art search, we can consider for filing different forms of patents and designs, whatever is suitable.
Ma'am, next question is from Ms. Sushlasan. Uh, Ma'am, it's about the citizenship and the rights related to it. Like, for example, if I'm not a US citizen or resident there, then can I get a US patent?
Yes, you can do that. But see, there are certain rules. So if you are an Indian citizen and you want to file an application in US, I'm taking one example. So either you have to file first application in India and wait for certain time and file an application in international market. If you don't want to do that, you have to take a permission from Indian Patent Office to directly file an application in US. So your nationalities will not decide the type of application or probably the jurisdiction of filing. Filing can be done across the globe. Even being an Indian citizen or sitting in India, you can hire local agents in those countries and file an application. But then certain countries need you to file first application in India or probably in your local country and then file an application in other countries. So that is the requirement in some of the jurisdictions, not all of the jurisdictions. So of course you can do that.
Okay. And the next question, of course, is that can I get a patent on my invention, but keep the most important part secret
Mhm.
so that
See,
others may not process?
ideally, see, as I said, that patent search would be done, right? So if you are not disclosing the invention as such, so idea will be that examiner will say that you are keeping it so broad that it cannot be made as such. So there is a requirement in the Patent Act which says that after this 20-year of time period when it goes to public domain, anybody should be able to replicate it and replicate it and make it. Best mode method need not be disclosed because that's not an Indian requirement as such. It was a US requirement. Best mode means that if you're heating it like on 5 degrees Celsius, so you need not to write like 5 degrees Celsius, probably a range would do like 3 degree to 7 degree or something like that. But then if your core novelty is not mentioned in the patent application, it will not be of any use and it will not eventually be granted. So you have to mention the point of novelty. Specifications can be narrowed down at the later stage. So ideal scenario is that draft a broad application, When the examiner says that, okay, fine, it is too broad, or you're trying to cover it in a very exhaustive manner, then you can narrow it down to an extent where the patent application can be granted.
Okay, ma'am. And ma'am, one of the last questions comes from me itself. Ma'am, I just want to ask that in this entire process of during this pandemic, what were the major filings for the patent which were having, according to you, some of the greatest ideas involving the innovations and the novelty, like which you can regard that it is something which is directly coming out of its like invention and during this process of pandemic and lockdown.
See, one was kits. So there were a lot of diagnostic kits which were filed in terms of patent application. Second domain, I'm just talking about what I mean, we were actually filing. So a lot of clients were coming up with those kind of innovations. Then there were device applications. Device applications means automatically sanitizing the you can say your non-living articles or your humans as well. So there were machines which were sanitizing humans, then there were machines who were sanitizing in different type of objects. Then lot of design applications for masks and pp kits were filed. So these were the prime areas for, I would say, at least 3 4 months. Post that, everybody started going back to their core business and created their technologies.
And on
Because
some of the business ideas also, were
no,
there?
business ideas will not fall under patent category. Business idea as such, idea as I was trying to explain you, will not be filed in any form of IP. You have to express it. The business ideas don't fall under patent category. But if you're writing probably a book on some kind of business idea, so that is more of a literary content that you're creating, you can file for a copyright application for that.
Okay, ma'am. Truly, we feel privileged that we had an opportunity to listen to Ms. Asia. Indeed, ma'am, your words and insight will pave a better way for understanding for all of us. We sincerely thank you for placing our program with your presence. Now, I would like to invite the one with whose guidance, support, and contribution we were able to put up such a successful event, our in charge, School of Legal Studies, Professor Dr. Gitu. Over to you, ma'am.
Thank you, Parishkar sir. Madam Isha, first and foremost, let me thank you to take out time for us and delivering such a wonderful lecture, talking about the theoretical and the practical aspects of patent and the COVID-19 issues and challenges. It was pleasant hearing you, and I think that you are not well. In spite of that, you have taken out time and you have excellently explained the concept. Thank you for being associated with us. We look forward to be associated in further workshops and seminars with you. With all thanks from the University of BABU Banarasi University and School of Legal Studies, we extend a heartfelt thanks. And thank you, Parishkar sir, for comparing and moderating the session. I would like to the opportunity to thank all my team members. That is Trishla, who is the department in charge, Sonali, who is the convener of this workshop, Mudita, Gunjan, Janmijay sir, and Swapna for being a part of this my heartfelt thanks to all the participants who have showed interest in participating in our workshop. We would like to make such programs more often so that the people can get aware of the legal issues and challenges. With thanks to all of you, I hand over the mic or leave the platform to Parishkar sir. Parishkar sir, please.
Thank you. Thank you so much, ma'am. Thank you for your kind words for our attendees. Lastly, I would like to just add that the days that break you are the days that make you. Because exceptional circumstances and situations also provide exceptional opportunities to every one of us. And this pandemic and this the whole year, the previous year, has also taught us that learning is unlearning what you thought you knew. The ways of nature are quite strange, and whenever I'm reminded about this COVID virus, I think in contrast about this very beautiful small flower of fuchsia. Let me just share it with you. Sonali ma'am, is it visible? Anyways, so this beautiful flowers and this flowers grows downwards and apart from other flowers, depicting a very beautiful fact of life that blooming is also possible when your world is turned upside down. And I wish each one of you to bloom your personality beautifully and don't let this pandemic hamper your capabilities. And if you are ingenious and innovative enough, then we have people like Ms. Isha Sharma to help us further. With that, this is Parishkar bidding you farewell from today's event and a big thank you to all our live viewers on YouTube for attending our program. Do like and subscribe to our YouTube channel and get notified for our next event. Till then, stay safe. Thank you so much, ma'am.
Thank you. Take care. Have a nice day.